All right, this case is now accessible to the public via our YouTube live stream, which is accessible via the court's website. I would hasten to remind everyone that with the YouTube live stream, the hearing does not last. It's not out there forever. And it is accessible, to my understanding, only so long as our hearing occurs. But it is an obligation of the courts to make the public's business accessible to it, and so we have satisfied that obligation. Who goes first?
I believe the state, Your Honor.
The state, Your Honor.
All right. Ms. Lindsay McClure is representing the state of Georgia in this matter, and Ms. Lipinski is representing Mr. Barr. So one thing that I think we're going to need to discuss on the record, Ms. McClure, is a waiver of Mr. Barr is not here. Again, everyone is appearing via the Zoom teleconference platform. And at this point, Ms. McClure, I'll hand it over to you.
Okay. Ms. Lipinski, your client, Mr. Barr, could not be here this morning. Did you have a chance to speak to him about this hearing?
I have.
And does he waive his right to be present for this hearing?
He does.
Okay. And I believe we have a witness via Zoom as well, a Dr. Polson. Is she with us?
She was.
Yeah, I'm here.
Okay, there she is. Okay. All right, Your Honor, just for the purposes of the record again, this is the state versus Alfonso Lamar Barr, case number 17 SC 15508. Good morning, Ms. Polson. Would you please raise your right hand? Do you swear or affirm that the testimony you are about to give in the court, before the court in this matter, will be the truth and will be nothing but the truth and the whole truth?
I do.
Thank you, doctor. All right, doctor, are you familiar with Mr. Alfonso Barr?
I am.
I'm sorry, counsel, would you please have her state her appearance, please? Her name and state her appearance.
My thing's breaking up. Would
you please have her state her appearance, please?
Her appearance, Samantha, you want her name and how to spell it?
Yes, her name, yes.
Okay, yeah, I was about
to say her name for the record.
Sorry about that. Doctor, could you state your name for the record, please?
Sure, my name is Tara Polson, T-A-R-A. Last name is P-O-L-S-O-N.
Good morning, thank you. Doctor, and are you familiar with Mr. Alfonso Barr?
I am.
And can you tell us how you are familiar with Mr. Barr?
Sure. Mr. Barr has been hospitalized with us here at Georgia Regional Hospital in Savannah since August of 2018, and I have been the psychologist responsible for his care for approximately the last year. I've had a consultation with his multidisciplinary treatment team throughout that year, and I am currently a part of that multidisciplinary treatment team.
Okay. And can you tell us about your what types of contact that you have with Mr. Barr?
So I have been consulting with the treatment team with Mr. Barr on at least a monthly basis. I have occasional contact with him directly on the unit where he resides, and that's essentially been it for the last year or so. Okay.
And you said you have monthly contact?
I have monthly contact with his treatment team about his case, and then I see him, as needed on the unit face to face.
Okay, thank you, doctor. And for the purposes of the court, could you please give a very short description of your background and education?
Sure. I have a doctorate degree in clinical psychology from Loyola University in Maryland. I have been practicing forensic psychology for the last 10 years. I have been licensed in the state of Georgia also for the last 10 years.
Okay, thank you. So you indicated that you have contact with Mr. Barr's treatment team. Have you recently evaluated Mr. Barr?
I have.
And when you evaluated Mr. Barr, did you determine that he is currently suffering from a mental illness?
And
Yes.
I'm going to object to leading.
Okay. I will rephrase, Your Honor. Doctor, can you please tell us about your evaluation of Mr. Barr?
Sure. So at this time, Mr. Barr is currently diagnosed with a schizophrenia disorder, and he has in recent months there have been notable improvements in his overall mental status, such that he has not been aggressive in approximately 6 months, and there have been some improvements in the symptoms of his mental illness. However, despite his general compliance with psychotropic medication, he continues to present with residual symptoms of schizophrenia, to include auditory hallucinations, paranoia, disorganized thinking, difficulty forming thoughts. And so even with medication, he continues to remain symptomatic.
Okay. So do you have an opinion about whether Mr. Barr is competent to stand trial?
So the current evaluation was not to address the matter of incompetency, as he's already been adjudicated by the court to be incompetent without the possibility of restoration. The current evaluation was to assess his civil commitment status.
Okay, thank you. And do you recommend that Mr. Barr remain civilly committed at this time?
And again, I'm going to object to leading.
Well, leading question is one that suggests the answer. I guess maybe a better, what is your recommendation?
Yes, Your Honor. My apologies. Dr. Paulson, what is your recommendation at this time for Mr. Barr?
My recommendation is that he continues to meet the criteria for inpatient civil commitment.
Is there, Dr. Paulson, is there anything else that you would like the court to know regarding Mr. Barr?
No, ma'am.
All right, Your Honor, at this time, the state doesn't have any further questions for direct.
All right, Ms. Lubinsky, would you like to cross-examine Dr. Paulson?
Thank you, Your Honor. Morning, Doctor. How are you?
Good morning. I'm good.
So, am I correct in understanding that there should be an individualized treatment plan for Mr. Barr?
Yes, ma'am.
And what is that plan?
So for Mr. Barr, he has a prescribed set of psychotropic medication, which have been adjusted, over the course of the last year or so. He also has a recommended set of psychotherapeutic groups and activities that occur both on the unit where he resides as well as off the unit at the hospital's treatment mall. Unfortunately, for about 6 months of the last year, that the individuals have been unable to leave the unit due to the COVID restrictions. So most of the activities have been on the unit, and it's only been in the last couple of weeks that they've been able to leave the unit again. During that time, Mr. Barr has been pretty reluctant to participate in the recommended groups that are included as part of his treatment plan. He has some troubles with initiation and motivation.
Okay, and you said he's on a host of medication, some of which was just changed over the last couple of weeks, if I'm not mistaken.
Yes, ma'am.
And he suffers from schizophrenia.
Yes, ma'am.
And as a result of that, he has some residual symptoms despite the medication. Will you describe those as residual symptoms?
Sure. So Mr. Barr continues to present with, he has paranoid delusions. He has auditory hallucinations, which means he continues to hear
Hi, how are
voices.
you?
He
Good.
is,
I like your mask.
Hang on
He-
just one second. Okay. I'm sorry, Dr. Wilson, continue.
Mr. Barr, can often be observed responding to internal stimuli, meaning that he appears to be hearing the voices. He has a hard time forming thoughts. You can kind of tell that like internally it's just struggling. And in our world, we call that thought blocking, where it's literally impossible for them to form a thought and then articulate it. And then, as I had mentioned, he has very poor motivation. He has a hard time initiating activity on his own. His self-care isn't great, although it is improved. His personal hygiene has improved, but again, it's not great. He is compliant with medication for the most part. But he frequently asks for medication to be lowered or discontinued. And it's only been recently that Mr. Barr has actually seemed to have come to an agreement with his prescriber about the medication dosage. So for the last month or so, he's been compliant, I do believe, 100% of the time.
I would imagine that being aware of your medications and asking for changes in dosage is a good thing, not a bad thing, because you are able to comprehend the effects they're having on you and ask that they be adjusted. Correct?
It can be a good thing, especially if one is noticing side effects that they would like to, ameliorate. In Mr. Barr's case, it appears to be due to his lack of insight into his mental illness and the need for the medication, as that's the primary reason why he continually asks for changes to be made or for medication to be discontinued altogether.
And let's say a lack of awareness about the nature of your illness is fairly common amongst people with this type of illness, correct?
Yes, ma'am, it is.
And the symptoms you described, the hallucinations, the paranoia, etc., that's also normal, correct, with people with this illness.
Yes, ma'am.
And there are people with schizophrenia who walk around on our streets on a daily basis.
That's true.
And they don't harm anyone.
Correct.
And they live their life to the best of their ability.
Yes, ma'am.
So let's see. Is Mr. Barr a danger to others?
At this time, his risk for imminent violence has decreased from this time last year. As I mentioned, he hasn't been engaged in an incident of physical aggression toward others in approximately 6 months. So at this point in time, I would say that he's not an imminent danger to others.
And is he a danger to himself?
Mr. Barr has never presented with behaviors that would suggest that he's an imminent danger to himself and that he's never exhibited self-injurious or suicidal type behaviors.
So why do you say he meets the criteria for inpatient civil commitment?
So the basis for our opinion is sort of that third prong of civil commitment, which is his inability to care for himself. Mr. Barr is symptomatic enough and impaired enough that if not in a setting like the hospital where there is supervision provided 24/7, where there are people to prompt him to take his medication, where there are people to prompt him to shower and change his clothes and attend to his activities of daily living, it appears that in his current state that Mr. Barr would rapidly decompensate in a less restrictive environment. And therefore, we believe that the hospital remains the least restrictive environment for him at this time.
What about something like a halfway house, which would be a less restrictive environment and would provide care and supervision?
Well, a halfway house is not a place that we would generally discharge folks to, especially from the folks that have outstanding legal charges. We will at some point consider potentially a community integration home, which is a home that's operated by the Department of Behavioral Health and Developmental Disabilities, or possibly a personal care home, or even a forensic apartment, which are located throughout the state. And I do believe that that is the direction that we are going with Mr. Barr. We're just not there quite yet.
And how long do you think it'll be before you're there?
My best estimate is if Mr. Barr continues down the path that he's on right now, meaning he continues to refrain from engaging in aggressive behavior, he continues to comply with medication, and if he can begin to initiate and engage in therapeutic activities, I do believe that within the next 6 to 12 months, we may be having a different conversation about his civil commitment status, certainly.
And if there's an improvement in 6 months, would you contact the court?
Yes, ma'am. At any point that an individual's civil commitment status changes, their multidisciplinary treatment team convenes here at the hospital to evaluate that status. And following one of those meetings, we would then contact the court with our change in opinion.
I have nothing further at this stage. Thank you, Your Honor.
Anything further for the state?
Your Honor, just one follow-up quick question. Dr. Polson, you stated to Ms. Lubinsky that Mr. Barr lacks the ability to care for himself. Could you elaborate on that just a little bit for us?
Sorry, they were making an overhead announcement here at the hospital, so it makes everything very loud. Okay. So the inability to care for himself is primarily related to his inability to sort of understand and appreciate the reason that he's taking the medication that he's taking. And therefore, if left to his own devices, if not supervised and prompted to the degree that he is in the hospital, our assumption is that he would likely stop taking the medication altogether. In addition to that, he has a hard time attending to his activities of daily living. And by that, I mean, showering, bathing, changing clothes, taking care of his personal space without some degree of prompting by the staff. So he's not able to do that entirely independently at this time. In addition to that, the issues that he has with being able to initiate activity on his own, the fact that he will not go to the treatment that is offered to him is problematic, because when he leaves the hospital, that will be an expectation. He will have to participate in some type of treatment. He won't be able to just lay around all day and not do anything. So we're trying to prepare him for that while he's here in the hospital.
Okay, great. Thank you, doctor.
You're welcome.
May I ask, and anyone can follow up on my question, and also anyone can object to my question, but Dr. Polson, when you say that you have observed Mr. Barr for a year, and correct? You need to
Yes,
say,
Your Honor. Yes, Your Honor.
and you have and during that year, whether he was 100% self-compliant or whether he was otherwise encouraged to be compliant, was he on medication throughout that year? Did that make sense? I can break that question down a little bit.
I got you, Your Honor. Yes, sir. Yes, sir. Yes, ma'am. He has been compliant. He has been on medication throughout the year, with occasional refusals of medication, but there's never been an extended period of time where he's been without medication in the last year.
Based upon your review of the record, of his medical records, I guess here's what I'm trying to ask, and maybe I don't need to be as careful as the lawyers. They can object if they don't like my question. You've told us today that he's not necessarily in imminent danger to himself or to others. Is that possibly because of the medication?
Yes, Your Honor, I would say that it's very much due to medication and his general compliance with the prescribed medication.
And just my layperson's understanding of schizophrenia, its hallmark is, as soon as people start feeling better on medication, they want to stop taking the medication. Is that, from my layperson's point of view, is that accurate?
It's certainly an associated experience with folks with schizophrenia. I think even more so, it's the general lack of insight into their mental illness, that at no point do folks with schizophrenia, and this is a generalized statement because there are plenty of folks with schizophrenia who do have insight, but there are also a significant number who don't have insight. And so without the prompting, without the encouragement, without the follow through, they are very likely to stop taking their medication.
Okay. Anybody want to follow up on my questions, state or defense?
Well, may I, Your Honor? Let's see. A lack of desire to take medication is pretty typical amongst people with mental health problems because the medications have side effects.
Yes, ma'am.
Those side effects perhaps sometimes make them feel sleepy or not themselves.
Yes, those are some of the common side effects. Yes, ma'am.
And that's why I kind of think it's a good thing that he can go to his psychiatrist and say, I don't like this medication. Could you change it? Correct? And he did that, didn't he?
Yes, although, as I had mentioned, in Mr. Barr's case, it appears to be more so related to his desire to not be on medication at all, rather than the addressing of the side effects.
When we spoke last week, I think you told me he requested a change from Zyprexa to Seroquel. That's correct?
Yes, ma'am. And that change was made.
So he, Mr. Barr, spoke to his psychiatrist and said, hey, I prefer the effects of Seroquel to the effects of Zyprexa. Correct?
Yes, and that was a very positive exchange on Mr. Barr's part. You're absolutely correct.
And that's incredible, isn't it? I mean, it's a guy saying, hey, I know what makes me feel better and what doesn't. Correct?
Yes, and we're hoping that he can do more of that, because that, you're absolutely correct in that does demonstrate some degree of insight and willingness to take medication, just to take the medication that he prefers.
And he didn't just do it willy-nilly. He spoke to his psychiatrist and an agreement was reached. And he was tapered off one medication and put onto another.
That's correct.
And the same type of thing could happen in whatever type of less restrictive environment was chosen for him, whether by way of a forensic facility of some kind, a group home, a personal care home, or whatever. Correct?
Yes, ma'am.
And it could be staffed by people, or it would be staffed by people whose job is to ensure that he does take his medication.
Yes, ma'am.
And that he does shower regularly and change his clothes regularly, correct?
The level of oversight over those types of activities would depend on the type of placement he was in the community.
And that would give him perhaps.
Ms. Lubinsky, I can see the path, not straight, but I can see the path to these questions following up on my question. So I have no problem with your scope. I think that I can see it. However, it is completely duplicative of what you've already asked and what Dr. Paulson has already answered with regard to the scale down, which she has said she would notify us of. So do you have anything else?
No, thank you, Your Honor.
Anything else for the state?
No, Your Honor, I don't have any follow-up questions.
Dr. Paulson, before we let you go, does the state have any other witnesses?
No, Your Honor.
Okay. Dr. Paulson, before we let you go, does Mr. Barr have any witnesses?
No, thank you, Your Honor.
Okay. Are we at the argument stage?
I believe so, Your Honor.
So,
Dr. Paulson, can you stick with us just one moment? All
Yes,
right.
Your Honor.
State, I guess, gets to go. I don't know. Who'd like to go first? Ms. Levinsky?
I think it's the state's burden, so.
okay.
Laura?
Yes, Your Honor. Your Honor, you heard Dr. Paulson testify and answer questions about Mr. Barr's mental health condition. He suffers from schizophrenia. He has benefited over the last year from being in a restrictive environment. And the doctor testified that he still suffers an inability to care for himself, even basic things as showering and taking his medications. The doctor, stated that he would benefit from continue inpatient civil treatment. And that, while he doesn't pose an imminent danger to himself or others at the moment, he would still benefit from being civilly committed at this time. Your Honor, the state would just argue that, Mr. Barr needs to remain an inpatient civil commitment treatment. He needs a structured, restrictive environment. And, the doctor testified that, hopefully 6 to 12 months, we can get him to a point where he can be moved to a less restrictive environment. Mr. Barr needs to continue to take his medication, and the state would just argue that we need to extend the order.
Thank you. Ms. Lubinsky?
And Your Honor, it's my respectful submission that Mr. Barr does not meet the criteria for the most restrictive level of civil commitment. He's not a danger to himself or to others. The suggestion is that he is not capable of caring for himself. There are other facilities available in which he would be able to get the supervision necessary to assist him in caring for himself and give him the incentive to actually do so. There's clearly a level of improvement, huge level of improvement actually over the last year or so, but he can't be in the hospital forever. And we need to start getting him out of there. And the way to do that is to perhaps look at moving him to a less restrictive level now.
All right, thank you very much. And Dr. Paulson, one of the reasons that I asked you to stay on the line is because, first of all, I want to thank you. Secondly, I do find that Mr. Barr meets the criteria for continued commitment, specifically the prong that you discussed with regard to self-care, but also just a stabilization as to prongs 1 and 2, as far as continuing this trend towards not being a danger either to himself or others. I think we all have to acknowledge that we've all been restricted in our movement, and there could have been more observation, and there could have been perhaps a greater insight into his interaction with others in some of these off-unit opportunities that Dr. Polson talked about, but that's the world we're all living in right now. I think Dr. Polson has impressed me with her motivation, and I'm sure the entire staff's motivation to look for these other opportunities and to notify us of these other opportunities. So one reason I wanted Dr. Polson to stay on is because I wanted to thank her, but I wanted to express this court's desire, Judge Barwick's desire, but the entire court's desire, but particularly my desire to not lose track of these cases. I mean, we have a huge volume, Dr. Polson, and I'm sure you're blessed with a similar volume, unfortunately, but I'm determined to make sure we keep our eye on it's not only our solemn task as a court, but as humans on the least of these. And I think that Mr. Barr, thank heavens, is perhaps showing a way to get to this next level, and I'd like to keep an eye on it. So I thank you so much for your work in that. And but I do find that we're going to stay with this program, and we look forward to hearing from you in the future. If there's nothing further, we'll conclude this record. Ms. McClure, will you prepare an order?
Yes, Your Honor. Okay.
Dr. Polson, how much do you like Zoom right now? You could have been enjoying I-16 twice.
I'm hoping that if anything good comes out of this whole COVID thing, is that the Zoom and WebEx hearings stay just like this. This is very convenient.
I'm not always sure I like Zoom, although I've been wearing shorts for about 6 months now. But I bet you like it today, and for that reason, we'd like to keep you at work doing a good job rather than on the road. So
thank you.
Thanks again, everybody. And Ms. Lubinsky, I want to thank you for the passion you bring for all your clients, but particularly in this case.
Thank you.
Thanks.
Thanks, Dr. Polson.
Thank you, you all.
All right, let's regroup and see where we are. Thanks, Ms. Lubinsky. That was a good job. That was your characteristic good job, but with a cluster for a little extra oomph. Okay, Kathy, what's next? I see
You want to
Mr.
start at
Adams.
number 1? And I think we can get rid of some of these fairly quickly.
Well, now, Kathy, does that mean fast justice without due
No, ma'am.
consideration?
That
Okay.
means some of these are going to be reset, and the other ones we're going to have to hear. So,
All right. Well, then let's see what we've got, which one of those we're going to get with Mr. Adams. Good morning, Mr. Adams. It's good to see you. How was your other hearing?
Very good. Thank you. Thank you.
Good. Well, it's always good to see you. And we've got Mr. McGee on the calendar this morning. What do we need to get done on that?
That'll be a negotiated plea. We need to clarify one thing. He is on probation. We'd like to take care of the probation issue also, maybe before.
Okay. Do we have Mr. McGee?
I
Are
told
we
him
going to do the plea? Is he on the, does his title say Smalls? Is that who that gentleman is?
No, I think that's the mall, the psychiatry mall. Where
he
Mr.
should be on there. And if he's not, I can call him and get him to get on.
Okay. The only other person we have on the screen right now is call-in user. Is that Mr. Derek McGee? Does call-in user mind identifying him or herself? Mr. McGee? You think that's he?
I
He
believe so.
doesn't. Let me see if I can. He's not on mute, or call-in user is not on mute. Have you heard from Mr. McGee? Did you expect him to be?
Get in the link. He should be on there.
Okay. All right, well, let's see. Who did you think that man was, Ms. Lubinsky?
That mall thing was Mr. Barr. That SJ something mall was Mr. Barr.
Oh,
Well, then he'll come, hopefully he will come back. No,
But this
Mr. Barr?
is, yeah, the guy from the last hearing was
Oh.
that mall thing.
Oh,
Jack.
okay, I didn't realize he was on at all.
Oh no, he was there.
Okay,
He was there.
okay. Well, we may need to go back and perfect the record on that, but, okay. So we don't have Mr. McGee.
so it looks like he's calling him, so maybe we can move on. Do we need Miss
Okay.
Porter anymore? Is she gone?
No, she talked to Ms. McClure, I think.
Okay,
80427 4043 3092.
Okay.
so let's see, we have Goolsby, Evans. So we have a few bonds. So I guess we can go in order, maybe?
Fine with me. That would make our next one, Mr. Gaboyd.
Yes, Your Honor.
Are you ready to go forward on Mr. Gaboyd?
Your Honor, I'm not sure what the state wishes to do today on Mr. Gaboyd.
Your Honor, the state wanted a chance to speak with probation and see what they're looking for on the probation revocation.
You want me to put you in a chat room?
We can do that.
Oh, boy, Judge Barr.
Do you?
Funny.
Ms. McClure, do you want me to put you in a chat room with Madam Probation?
Yes, Your Honor.
Breakout room? Okay. No, I don't know. Okay. Generally, you put everybody in the breakout room. Okay, so I'm gonna put Lindsay McClure, probation. Oops. Okay, did I just invite everybody? I don't know how to do it otherwise. You guys go
Okay, I
to
see
the
it.
breakout room. Nobody else go to the breakout room. Is Mr. Gaboyd in custody, Ms. Levinsky?
Yes.
Okay. Ms. Lubinsky, are you doing Matthew Cantrell as a mere volunteer?
Yes.
Thank you.
Well, I guess we have to wait for Lindsay.
No, get it
Oh.
the other side.
I was looking to see if we had anybody else we could do, but no. And everybody's having problems with Odyssey. I'm getting emails from all the case managers that we can't look at anything. And
I was having that earlier as well.
Yeah, I can't get in. I can see the page, but I can't open any documents.
yeah, I thought today I was going to be able to be on the computer and doing Odyssey, and it's not working today.
So Kathy, that's a cool room. So what, is it real brick?
No.
It's
The people who lived here before had that. And it might be real brick. I don't know. Isn't that crazy?
I love it.
Yeah,
Now, is that Chuck's area back there?
that's Chuck's area on that side. Yes.
That is very, very neat.
Yeah, so we both have our little desk down here, but I like being upstairs with the windows when I'm on, working. So I'm usually working upstairs, but
you print and scan down there,
down here,
right?
yes. So I have my little scanner, and this is my puzzle also I have down here.
You say your what?
I have a
glass?
puzzle.
Puzzle, oh, okay.
Yes,
Looks like you just about completed.
I'm getting there. And then my scanner and stuff's right there. So I've got everything kind of down here, just
That's what I need, a scanner.
yeah.
You don't have a scanner, Samantha?
I don't, Judge. That's why every now and then you see me too. One of the reasons. I have everything else except the scanner.
Donna, may I interrupt?
Of course.
I talked to Mr. McGee. He was waiting on my call, so he's coming in now.
Great.
Yeah,
Okay.
Is
I'm
the
here.
678 number coming in?
I'm here.
Okay, Mr. McGee, it's good. Is it possible for you to get video or just audio?
I'm doing audio right now. I don't know how to do the video, but I don't know how to do the video.
Okay.
Mm.
All right, we're waiting for the DA to get back on. She's having she's on another call right now. So we'll get started in a minute.
Okay,
So,
thank you.
what is the plea going to be, Mr. Adams?
It's 5 years of service, 1 community time served, balance probated. That's continuing on probation under 17 SC 154101.
5 years, serve 1, community time served, balance on probation.
Correct.
Yes. Well, let's see if Odyssey will work for me to do the plea sheet now.
Okay.
Ms. Lebinsky, if they come back with a good offer on probation, will we do that today or?
I don't, on Gaboyd? I don't
Yes.
think so. Because, I mean, he's got this other, oh, I suppose we could.
Okay. Look at them, they're back. We missed you guys. Okay, Ms. McClure, Mr. McGee has joined us.
Okay.
So if it's possible to go ahead and take that plea, does anybody have a problem since that was number 1 if we go ahead and do that?
Okay. No, I don't have a problem, Your Honor.
Okay, now here's a layer that I have not had, I don't think. We can't see Mr. McGee. We can hear him, but we can't see him. I hadn't done one like that. So does the state have any objection to that?
No, Your Honor, I can question his counsel whether he waives his
Okay.
physical appearance.
Okay. Well, I mean, all right. Then Samantha, you ready to start this one?
Yes.
Okay. This is the state of Georgia versus Eric Verneri McGee, and this is 20 SC 174571. Today is October 13th, 2020. I am in courtroom 8A, but our courtroom is not open. By the way, I'm told that there's renovation to the heating system going on, and that is the reason that it's not open and we don't have a sheriff. Nevertheless, we are on YouTube live stream, and that satisfies our obligation to make the public's business or to keep the public's business open and accessible to it. And that's something that we take very seriously. We are all appearing via the Zoom teleconference platform. Mr. McGee appears on our Zoom conference. He appears by audio only and not by video. So the first question that the court had for the state is whether the state had any objection to not being able to see Mr. McGee. Again, I'll let Ms. McClure speak to that, but I understand that the state does not. I know that Ms. McClure will probably want to ask Mr. Adams about Mr. McGee's right to be present in the courtroom. You know, I'll turn that over to her in just a moment, but I do understand that we have a negotiated plea in this case. And at this point, I will turn the matter over to Ms. McClure.
Thank you, Your Honor. Good morning, Mr. Adams.
Good morning.
Your client is appearing via telephone, but not video. Does your client waive video presence?
He does. That is my client. I recognize his force, and he will waive a presence.
Okay, thank you, Mr. Adams. Good morning, Mr. McGee.
Good morning.
Where we are, will you please raise your right hand for me?
Yes,
Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
I do.
Okay. Please state your true, correct, and legal name for the record.
Derek Venari McGee.
Okay. Can you please spell that, please?
DERRICK VERNARIEMCGHEE.
Thank you. Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No,
Is there a medication that you normally take that you have not been given today?
no,
How old are you and how far have you gone in school?
37 and 10th grade.
Okay. Are you able to read, write, and understand the English language?
Yes,
Do you understand that you're charged with the following offenses? Possession of marijuana with intent to distribute, theft by receiving stolen property, and possession of a firearm by a convicted felon.
yes,
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial?
yes,
Have you had enough time to speak with your attorney, Mr. Adams, about all the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
yes.
Do you need more time to discuss this case with Mr. Adams?
No,
Counsel, do you waive formal reading of the indictment?
We do.
Do you waive any and all defects in the indictment?
We do.
Mr. McGee, have you been arrested on these charges?
yes,
The state is unaware of any outstanding warrants related to these charges. Do you or your attorney know of any outstanding warrants that are related to these charges?
We do
No.
not.
Has your attorney advised you of the minimum and maximum sentence for each charge that you're pleading to, that you could face 1 to 10 years on possession of marijuana with intent to distribute, 1 to 10 years for theft by receiving stolen property, and 1 to 10 years possession of a firearm by a convicted felon?
yes,
Do you understand that this is a negotiated plea of guilty, which means that the state will recommend to the court a sentence of 5 to serve 1, balance probated on count 1, possession of marijuana with intent to distribute, count 2, theft by receiving stolen property, 5 to serve 1, balance probated, Count 3, possession of a firearm by a convicted felon. 5, to serve 1, balance probated, to run concurrence with counts 2 and 1. That you also participate in random drug and alcohol evaluations, and that you will attend 1 Narcotics Anonymous meeting a week.
Yeah, and I think the next recommendation is 5 years to serve 1. Credit commuted for time served.
Commuted to time served, okay.
Ms. McClure, I'm sorry, do you mind stating the other conditions, please?
Yes, Your Honor. Your Honor, yeah, he will submit to random drug and alcohol evaluations. And he will attend 1 Narcotics Anonymous meeting per week for a year.
Okay.
Mr. McGee, do you understand that the court does not have to accept that recommendation?
Yes.
Do you understand that the court can sentence you to the maximum on each charge and can run those sentences consecutively?
Yes.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as in other jurisdictions, including the federal courts?
Yes.
Do you understand that if you are currently on probation or parole, your probation or parole may be revoked based on you entering a guilty plea today?
Yes.
Do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to the revocation for the balance of the sentence?
Yes.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes.
Are you a United States citizen?
Yes.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial? For example, your guilty plea may affect the right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you will be guilty of a felony, which may carry a sentence of 1 to 15 years in prison?
Yes.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes.
Do you understand that if you went to trial, you would have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to testify or remain silent and not incriminate yourself?
Yes.
Mr. McGee, I'm going to read a list of rights to you that you are giving up by pleading guilty today. After I go through the list, if you will just answer. Do you understand that you are giving up the following rights? The right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to assistance of counsel hired by you or to court-appointed counsel, the right to the presumption of innocence, the right to testify on your own behalf and present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after trial. Do you understand those rights?
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Your Honor, we like to enter this plea under North Carolina versus Alford.
All right.
Okay. Mr. McGee, are you pleading guilty because you have decided that it is in your best interest to do so?
Yes.
Are you aware that even if you do not admit guilt, this is a plea of guilty and places you in the same position as if you were convicted by a jury at a trial?
Yes.
How do you plead to the charges of possession of marijuana with intent to distribute, theft by receiving stolen property, and possession of a firearm by a convicted felon in indictment number 20 SC 174571.
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
Do you understand that you may have only a limited right to appeal this guilty plea conviction?
Yes.
Do you understand that you only have 4 years from today for a felony charge to file a habeas petition challenging the voluntariness of this guilty plea?
Yes.
And Your Honor, the factual basis for the plea is as follows. If this case went to trial, the state believes the evidence would prove beyond a reasonable doubt that on January 3rd, 2020, at 876 Martin Luther King Jr. Drive, Southwest Atlanta, located in Fulton County, Georgia, officers were conducting surveillance at the location. And when they noticed individuals inside of the Town Market convenience store selling drugs, they noticed multiple people in the group. They kept going out to the car to the passenger side of a white Dodge Durango. Officers observed an individual rolling a marijuana blunt and smoking it. He passed it to the other members of the group of people. At that time, officers contacted other members of the unit, arrived at the location. They detained all parties that they witnessed previously selling drugs. They conducted a sweep. K9 alerted positive on the Dodge Durango and also a white 2000 Ford Crown Victoria. The Ford Crown Victoria belonged to Mr. Derek McGee. Mr. McGee was also detained. After he was detained, his car, the white Ford Crown Victoria, was searched. They recovered 37 grams of marijuana, a digital scale, a handgun, and $134 in small denominations consistent with the illegal sale of drugs from the vehicle. As a result, Mr. McGee was arrested and detained and charged accordingly. And Your Honor, the negotiated plea that we have agreed to, I'll just repeat again for the court. Mr. McGee will plead guilty to count 1, 2, and 3. On count 1, Mr. McGee will have 5 serve 1, balance probated, commuted to time served. He will submit to random drug and alcohol evaluations. He will attend 1 Narcotics Anonymous meeting per week for a year. And that is to run concurrence with count 2 and 3 as well. And on count 2 and 3, he will also 5 serve 1, balance probated, commuted to time served with the same conditions as tied to count 1. Nothing further from the state, Your Honor.
Anything on Mr. McGee's background? Obviously, there must be a felony back there somewhere. Or what?
Yeah, my apologies, Your Honor. I forgot, I left that part out. Yes, Your Honor. The state has 5 felony convictions for Mr. McGee. The first felony conviction the state has is from 2018. It was for aggravated assault. The second conviction the state has is from 2017 for aggravated assault. The third conviction that the state has is from 2011 for theft by receiving stolen property. The fourth felony conviction the state has is from 2006 for possession of cocaine with intent to distribute. The fifth felony conviction that the state has is from 2002 for possession of cocaine with intent to distribute.
All right, thank you. Is he on probation for any of these things right now?
I believe he is on probation, Your Honor.
Yes, as was stated before we started, that we'd like to take care of that matter too, also.
Yes, good morning. I am not seeing the probation matter. Is there a docket number associated with it? Because I see several different Derek McGee's. And
I'm showing 17 SC 154101.
okay, just give me a couple of minutes. Okay, I'm showing a different alias. Is this Geoteus Easley?
No. Let me give you another number also, 19 SC
Mm-hmm.
170853.
Um, 19 SC 170853.
Right.
That one isn't going through.
That might have been a reindictment.
Okay. Miss McClure, do you have any docket numbers for any of the previous, like the most recent one, maybe the 2018?
I don't. I have a conviction from 2018. Let me look up and see if he's on probation on that, because my records, it doesn't, I don't have him on probation.
Yeah, I'm not seeing anything either, but
Let me look on my end and see.
Ms. McClure, are you having trouble with Odyssey?
Yeah, some of
I
the,
have a couple of probation. I have a 17 and a 16. No, that's a time served, the 17. Let's see.
yeah, my Odyssey is not wanting to open anything right now.
Yeah, I can't look at
Odyssey is not working.
Yeah, but
Right.
I don't have in my records, I don't have him on probation. I mean, unless it's from he's on probation in a different county, unless he's on probation for the 2018 conviction, but I can't get into to Odyssey.
I see one that was on probation. It's 17 SC 154101, and that's the only one that it's showing on that I see right this moment. So, and that's the one you said he was not on probation.
Can
For
you give me
that
that
one, I'm
number?
going to
Can you give me that number again?
It's 17 SC 154101, and that's the one that Mr. Adams had said before. Let me see if there's another.
And you don't show him, Madam Probation, you don't show him as being on probation in that 17 case?
no, Your Honor.
Yeah,
Nothing's popping up for that.
Yeah, that case is not even coming up in my system.
Okay.
What if,
Well, he has a different alias? I'm showing that he has a different name. So I see a note that popped up here. Does he? Maybe Mr. McGee can answer it. Does he go by Jotavius Easley?
Yes.
Okay, so yeah, I see. Okay, so that one I do see 3 different open probations for that one. You want to give me a minute? I can calculate the time frames that he have left on those.
What did it say?
Just as a side note to everyone, our IT department has encouraged us to log out of Odyssey and to log back in.
So he does have a warrant for the 17 SC 154101 case for violation of criminal law. For on or about 1/4/2020, committed a new offense of purchase, possession, manufacture, distribution, and sale of marijuana in Fulton County, Georgia.
I'm sorry, say that again. What was that for?
For the 17 SC 154101 for violation of criminal law on or by January 4th, 2020, for the offense of purchase, possession, manufacture, distribution, or sale of marijuana, and theft by receiving stolen property, and possession of a firearm by a convicted felon in Fulton County, Georgia. And for that one, he has right now. So for that one, he has 5 years, 5 months, and 10 days remaining.
Well, what's the recommendation as far as that is concerned, as that probation is concerned?
To my understanding, Your Honor, we were going to
We
revoke.
continue him.
I beg your pardon?
Go ahead, Mr. Adams.
Can you hear me? Okay.
Yes,
Can you hear me now? Hello?
Yes,
yes.
yes.
Yeah, my understanding from Mr. McCall, we were going to revoke the time he served and reinstate. In other words,
Okay.
run everything together, you know, concurrent.
Is that acceptable to the state, Ms. McClure?
Yes, Your Honor.
Would that
Is
go
that
for the remaining probations? I'm sorry.
The suggestion is to revoke the time that he served on the 17 probation violation and continue him on that probation. So he'd have two simultaneously. But the 17 case looks like it'd be longer.
Yes, Your Honor. So for the remaining, the 2 remaining, are we going to revoke those as well? Revoke the time served?
I'm sorry, I thought there was only one outstanding
No, Your Honor.
probation.
He has
Okay.
two other.
Can you give us those numbers, please?
Yes, I'm sorry. I was busy calculating the dates for the time remaining.
That's fine.
Okay, so for the he has a 16 SC 142507 in Fulton County, Georgia. That one ends May 22nd, 2025. He has 4 years, 7 months, and 9 days remaining on that one. And then he has a 17 SC 154385 in Fulton County. That one ends March 24th, 2026. He has 3 years, 5 months, and 10 days remaining on that one.
So 17 SC, you said 154385?
Yes, Your Honor.
Okay. So what's the recommendation with regard to those two?
Same, Your Honor, revoke the time he served, reinstate, run concurrent with the 20 SC 174571.
What's the state's recommendation?
Mr. Adams, is that what you and Ms. McCauley had agreed to before?
Right.
Okay.
Right.
The state will agree with that then, Your Honor.
Okay, Mr. Adams, anything on behalf of Mr. McGee?
No, Your Honor, we just ask you accept the recommendations.
Okay. Mr. McGee, can you hear me, sir?
Yes, ma'am.
Okay, I have some questions for you, Mr. McGee. Did you understand the questions asked of you here today by the Assistant District Attorney, the lady who asked you the questions?
Yes.
Do you understand the rights you're giving up by entering your pleas today?
Yes.
And I understand you're entering your plea in this case under the Alford case. So you are entering your plea because you've decided it's in your best interest to do so?
Yes, ma'am.
Has anyone promised you anything to get you to do that?
No, ma'am.
Has anyone threatened you in any way to get you to do that?
No.
Are you satisfied with the services of your attorney, Mr. Adams?
Yes.
And do you believe you've had adequate time to discuss this case with Mr. Adams?
Yes.
Mr. Adams, do you believe you've had adequate time to discuss this case with Mr. McGee?
I do, Your Honor.
And do you believe Mr. McGee understands and appreciates what he's doing today?
I do.
All right. Well, I find that Mr. McGee is entering his plea willingly, freely, knowingly, and voluntarily. I will accept his plea as an offered plea. And I will accept the recommendation reached between the state and the defense. I've got one question to ask y'all. Does everybody, and I'll start with you, Ms. McClure, do you consent to the court signing your name on the indictment?
Yes, Your Honor.
Mr. Adams, do you consent to my signing your name on the indictment?
Yes, Your Honor. I do.
Mr. McGee, do you consent to my signing your name on the indictment?
Yes, I do.
Okay. Then in 20 SC 174571 on count 1, possession of marijuana with intent to distribute, the court hereby sentences you to 5 years to serve 1 year. That 1 year will be commuted to the time served with the balance to be probated. Special conditions of your probation are random drug and alcohol screening, that you attend 1 Narcotics Anonymous meeting per week for 1 year. Your compliance with that will need to be reported. And finally, although no one has said it, and I believe it goes as probably a general condition, but you're not supposed to have any firearms, Mr. McGee. Not near you, not on you. You're not to possess them, own them, transport them, sell them, buy them, trade them. Let's just leave the firearms out of your life, okay?
Yes.
Is that a yes? Okay. All right, now,
Yes, ma'am.
sentences on counts 2 and 3 are the same thing, all to run concurrently. Now, with regard to your probations, Mr. McGee, I will accept the recommendation, and on 17 SC 154101, on 16 SC 142507, and on 17 SC 154385, the court will revoke those probations for the time commuted to the time served and continue you on those probations, meaning you will have 4 simultaneous probations, which means you did a bunch of stuff in a short period of time. And I'm not really sure why. I'm assuming that the Narcotics Anonymous has something to do with your having an addiction problem. But whatever it is, Mr. McGee, we don't need to see you with this frequency or this regularity. And I'd like some affirmation from you that you get it and you're tired of seeing us too. Is that correct?
Yes, I'm serious. Yes.
Okay, is there anything else from anyone?
Yeah, and I just need to give him report and instructions when we're done.
All right, and I would like any probation violations to be specifically returned to me. You're through with firearms, Mr. McGee.
Yes, ma'am.
Understand?
Yes,
All right,
ma'am.
go to the Narcotics Anonymous. You know, you gotta go, so go. But please have an open mind with those meetings. You may be sitting next to somebody in one of those meetings who's there voluntarily because they are in desperate need of help. And maybe you might be able to help somebody. Okay?
Okay.
Okay. All right. If there's nothing further, we'll close down that record. Thank you, Mr. Adams. Thank you, Mr. McGee.
Thank you, Maybe.
Thank you.
Excuse me. Sorry, Your Honor. May I please give him reporting instructions on the record?
Mr. McGee, you're going to have to write something down. This lady's going to tell you what to do about your probation. Go ahead.
Yes, Mr. McGee. Are you currently residing in Fulton County, Georgia?
Yes.
Okay, you're expected to report in person to the Department of Community Supervision in Atlanta, located at 276 Memorial Drive, Southwest, Thursday, October 29th, 2020 at 8 a.m. Get ready to report. Warrant. Do you understand, sir?
All right. I just about to say, so I'm gonna have to do probation officer because I already got a probation officer and she come by and see me.
Okay.
So this is gonna be a general.
Well, this is just for intake. So you'll keep the same probation officer. This is just for intake because of the new case.
Oh, all right.
Okay. All right.
All
Just
right.
remember October 29th. That's a Thursday at 8 a.m.
All right.
All right. Thank you.
All right.
Thank you.
Okay. Thank you. All right. You're excused, Mr. Adams. Thank you, Mr. McGee. All right. What's next? Jorge Gaboyd. Is that one next?
It looks like it.
That's fine.
Okay. Is this going to be a hearing? Do we need to be on the record? Is this the case that probation and the state talked about?
Yes, Your Honor, we did talk about that. What probation and I discussed is he's actually got a new case, and probation and I both agree that we would like to resolve both of those at the same time. So we would at this time like to hold off until we can get the other case resolved. That way we can do everything at one time.
Is he in custody?
Yes, Your Honor, he is in
Can we get it
custody.
resolved? Can
The
we get it resolved
plan,
Thursday?
the
Can
plan,
we get it
Your-
resolved by?
no, Your Honor, we need to find something for him. This is not a case to rush. He came out of prison out of the state system on May the 14th. He got arrested, I think, on May the 30th. We need to find him something. And that may take time.
Okay. Do you want to go forward today, or do you want to wait
No, I
until we
don't.
can find?
I want to wait until we can find something. And
Okay.
Your Honor, it may take time. This is not going to be an easy one to find, but I think we do need to do it.
Okay.
And if you can give us a little bit of time to find a program for him, once we find one, I'll alert Kathy and Miss McClure, and we can get him on.
Okay, thank you very much. Okay, before we talk about Mr. Goolsby, there's a couple of other ones, Norris Evans and Matthew Cantrell. Can we do those first?
Sure.
Are we ready to go forward on Mr. Evans?
Yes, Your Honor.
This is a motion to set aside his warrant and reinstate his bond.
There are actually two motions. One is to set aside his warrant and reinstate his bond. The other's a motion to dismiss. And the basis of that is that.
Can you give me one moment? I'm going to mute for one moment.
Sure.
I'm sorry. Do we need to start our record, or are you kind of helping me with a little bit of an overview, Ms. Lubinsky?
I guess we could start our record. Ms. McClure, have you got any kind of announcement on this one?
Your Honor, the only announcement I have is I've spoken with Ms. McCauley about this case. And obviously, we need to discuss this case more with Ms. Lubinsky. But the state, at this time, we're not going to dismiss the case. So.
Okay.
And we oppose. We oppose setting aside the pretrial warrant.
All right, then let's go. Samantha, you ready?
Yes.
All right, this is the state of Georgia versus Norris Evans. This is 20 CP 190131. The case is on the calendar this morning for a motion to set aside a pretrial warrant and reinstate bond, and also for a motion to dismiss. And we are appearing via the Zoom teleconference platform. I am in courtroom 8A, but our courtroom is not open to the public. We are, however, on the YouTube live stream link through the court's website, and therefore we've satisfied our obligation to make this matter accessible and open to the public. However, we do not have Mr. Evans present in court, nor on Zoom. So representing the state is Ms. Lindsay McClure. Representing Mr. Evans is Ms. Jenny Lubinsky. And Ms. McClure, I will turn it over to you to see if the state has any questions for Ms. Lubinsky as to Mr. Evans not being in attendance today.
Thank you, Your Honor. Ms. Lubinsky, have you had a chance to discuss this case with Mr. Norris or Norris Evans?
Evans, yes, I have.
And does he waive his right to be here today?
He does indeed.
Okay. Thank you, Your Honor.
Thank you. Would you like to proceed, Ms. Lubinsky?
And Your Honor, this is a motion to set aside a pretrial warrant and reinstate his bond. And Your Honor, Mr. Evans is 66 years of age. He was arrested on February the 25th on a charge of possession of cocaine with intent to distribute and driving on defective tires. He was in jail from February the 25th until June the 18th, when he was released on a signature bond through pretrial services with level 2 supervision. On September the 17th, he was arrested on a warrant issued by pretrial services on July the 21st, apparently as a result of his failure to report. And Your Honor, there are two aspects there. One is that And I don't know whether the court has any recollection of Mr. Evans. He's 66 years of age in extremely poor health. And Your Honor, after his release, we also reinstated his probation. And that's the reason this case is in this court, because we have a concomitant probation. So when we reinstated his probation, he was given instructions to report to probation. And he's been reporting to probation as required. And I actually clarified that with his probation officer, and Officer Middleton, who confirmed that Mr. Evans was actually in contact with him, even when he was in hospital and when he was homeless. He has now got accommodation. But even when he was homeless, he was in contact with Officer Middleton. He kind of didn't quite grasp the concept of the two different situations, probation and pretrial services. In addition, Your Honor, about a week and a half after Mr. Evans was released from jail, he was hospitalized at Grady because he had a swelling in his leg. It turned out to be a blood clot in his leg, caused amongst other things by the fact that he had the incorrect medication while he was in custody in Fulton. Your Honor, so that's the basis of the motion to set aside his pretrial warrant. He will live at 556 Joseph E. Lowry Boulevard. Now that he understands the concept of pretrial services and probation, he will comply with both. Your Honor, he has not picked up a new case. He has not done anything else wrong. The other thing, Your Honor, is the motion to dismiss. And Your Honor will have noted that these have been filed fairly regularly of recent months. And they originate from the fact that Mr. Howard, who is still the current district attorney, has gone on record as saying he does not prosecute simple possession cases. And our simple possession cases are largely being null-prossed because the state understands and accepts that these cases should not be indicted and prosecuted in our courts. Your Honor, was a small amount of crack cocaine found in Mr. Evans' vehicle at the time of his arrest. Your Honor, I would simply ask the court at this stage if the court is not prepared to dismiss, to reinstate Mr. Evans' bond through pretrial services, same level of supervision.
I'm sorry, you said same level? I didn't have to hear the last time. You said same level. What was that?
Same level of supervision. Sorry.
And I'm certainly anxious for the state to respond, but just before we get to that, let me just ask you, what are you suggesting that he was reporting to one but didn't understand that so Officer Middleton is saying, hey, he's been doing what I asked him to do, but he didn't understand he had dual reporting responsibilities?
Basically, yes. Basically, yes.
Okay. All right, Ms. McClure.
Thank you, Your Honor. So I'll just respond to Ms. Levinsky's motion to set aside the pretrial warrant first. Your Honor, the state would oppose setting aside the warrant for the very simple fact that Mr. Evans has an extensive criminal history. And, I know Ms. Levinsky said that he's been reporting to probation, but, we shouldn't be rewarding him for doing what he's supposed to do. He's supposed to report to probation. He was given a signature bond on this charge, level 2 pretrial supervision. He failed to report. As a result of that, Your Honor, the state would argue that the warrant should not be dismissed, that it needs to stay. Like I said, he's on probation already. He didn't report to pretrial. So and based on his criminal history, the state would argue that there's a risk of flight and there's a risk of him not doing what he's supposed to do. And regarding the motion to dismiss, Your Honor, this is not a simple possession case. This is a possession of cocaine with intent to distribute, Your Honor. The defendant was found with, the lab found 3.77 grams of crack cocaine. It was broken up into up into smaller pieces. And he was found with cash in his vehicle as well. So, Your Honor, this is not a simple possession case. It is a distribution case, and we would ask that you deny the motion to dismiss, Your Honor.
Okay. Ms. Levinsky, what is 566 Joseph E. Lowry Boulevard?
It's a house that he was able to obtain accommodation in when his SSI was reinstated. Now, because he was in jail, of course, he lost his SSI. He then had to wait to get his SSI back. He gets his SSI back. He gets accommodation at 556 Joseph E. Lowry Boulevard, and hey presto, he's arrested on this warrant. When I spoke to Officer Middleton, he expressed his disappointment that this had happened because he was pretty impressed with the way Mr. Evans had been conducting himself. Let me respond very shortly to what the state have said. He has a criminal history. It's old. It's all very, very old, except for the probation he took in this court about a year and a half ago. And that's after he was in jail, of course, for months and months and months, and eventually after the state had charged him with a host of charges, and then eventually brought it down to 1 or 2 counts of possession and gave him probation, the way we tend to do with cases we don't have a decent case on anymore. The man is 66 years old. He's a high risk of COVID. He's a greater risk of getting sick in the jail. and worse from COVID and from what's going on here than he is from fleeing the jurisdiction of this court.
Well, let me stop you. He was out from June to September and didn't pick up any new charges.
No new charges.
Okay, let me just stop you right there. I'm going to reinstate his bond, and I'm doing so for the following reasons. Number one, thought very long and very hard about it when I granted him bond in the first place. And I don't find him to be, I'm not ruling on the violations. I'm just reinstating his bond. I think I can do that. I don't need to set aside the warrant, do I? Kathy, what do I do? Well, let me continue. I'm reinstating his bond. And I hope he hasn't lost his SSI again. I'm not ruling on the motion to dismiss at this time for the following reasons. Technically, we're having a problem with our online docketing system. I haven't read it. I'm not even sure if anything was filed. I will look at it, and I've heard your argument, but I will, I'm just not deciding that at this time. I may call for further argument. Obviously, I hope the parties can talk in the meantime. I think that we help Mr. Evans figure out, figure out the dual reporting. I'm not relieving him of that responsibility. His situation has brought him to that point, and I believe they're letting people call in by phone now to report. If that's wrong, you can tell me, but he needs to abide by the provisions of both things. But I am reinstating this bond over the objection of the state. And Ms. Lubinsky, anything that you can do to encourage Mr. Evans to keep on the not reoffending path would be very much appreciated.
I'll try, Your Honor.
Okie doke. All right, that concludes Evans. I hope that was all crystal clear. And that, can we go ahead and do Mr. Cantrell before we go back to Mr. Boothby? Ms. McClure, are you representing the state on Mr. Cantrell?
Yes, Your Honor.
And are you doing so as a volunteer?
Yes, Your Honor.
Okay, well, I want to thank everybody for doing this. I cannot read his original bond, so if that could be part of anybody's presentation. But at this point, I'm going to call the case of the state of Georgia versus Matthew Cantrell. This is 20 CP 192795. Today is October the 13th, and I am in courtroom 8A, but our courtroom is not open to the public. However, we are on the YouTube live stream managed and made available by the court, keeping this court's obligation to have the public's business open and accessible to it. This case is on for a reconsideration, I think. It's a reduction, correct?
Yes, Your Honor, he has a bond.
Okay, so this is on for bond reduction. And I just want to say one other thing, and I'll turn it over to Ms. McClure. Mr. Cantrell is not present in the courtroom, nor is he present via Zoom. So at this point, I'll turn it over to you, Ms. McClure, to see whether you would like to ask any questions regarding Mr. Cantrell's appearance.
Okay, thank you, Your Honor. Ms. Lubinsky, have you had a chance to discuss this bond motion with Mr. Cantrell?
I have.
And does he waive his appearance today?
He does.
Okay. Thank you, Your Honor.
Ms. Lubinsky?
And Your Honor, Mr. Cantrell, he's 27 years of age, single, the father of 4 children, 2 of whom are with his co-defendant in this case, Miss Wooten. They are 7, so hang on, sorry, his 4 kids are aged 7, 4, 3, and 10 months respectively. The 3-year-old and the 10-month-old are children he has with Miss Wooten. They are in de facto custody in Bartow County. The remaining 2 children are with their mom in Douglasville. Mr. Cantrell was arrested on July the 11th. Judge Ashley set bond for Mr. Cantrell in an amount of $20,000. This was a bond he set on July the 13th, presumably at first appearance. There has been no preliminary hearing. The case has not been indicted. Mr. Cantrell has been unable to make the bond and remains in custody. Your Honor, the only reason Mr. Cantrell is in custody is because he hasn't got money to make the bond. Because by setting bond, Judge Ashley found that he met the criteria for release on bond. And Your Honor, he does indeed do so. Personal circumstances, as I said, he has 4 young children in the Atlanta, Douglasville area. His dad died when he was a child, but his mom, 4 older brothers, aunts plural actually, live in the Georgia area. He is a recovering drug addict, and Your Honor, he suffers from PTSD and bipolar disorder. The PTSD is, amongst other things, caused by the fact that he was present in the vehicle when his father was killed in a car accident. He has actually had a rather unhappy series of events. He found his brother dead, and Your Honor, there are reasons for his PTSD. His PTSD is being treated by a Dr. Meski, a Dr. Alexander Meski in Carrollton. And he's not receiving any of his mental health medications while in the jail. As far as his criminal history is concerned, he does have 1 prior felony conviction. It goes back 10 years to when he was 17 years old. And he was convicted of a count of burglary. My understanding is that he actually went to boot camp. His mom and stepfather were supposed to be on the Zoom call. His stepfather texted me to say there was a problem with the link, and he hasn't been able to join. The plan would be for him to live at his stepfather's home, mom and stepfather's home, at 139 Muirwood Drive, Temple, Georgia. He meets all of the Ayala factors. He is not a threat to anyone in the community. Your Honor, as far as the facts of this case are concerned, I was eventually able to secure a copy of the incident report. It's one of those cases you look at and say, do the police actually follow up anything before they arrest and lock a person up for months on end? Is there anything further on which the court would like to hear me?
When you say, okay, yeah, a couple things. Did the co-defendant get bond?
Co-defendant is still in, she's in on a $10,000 bond, which she also cannot make. She is his long-term girlfriend. They have been together 4 years. And as I said, the 2 youngest children are hers.
And if you know the answer to this question, I'll be impressed. Where is Temple, Georgia?
No idea. Literally.
Me neither.
I'm not from here.
I'm from here.
Like a lost.
Okay. All right. And I think that was my only. Does he work?
Oh, sorry, Your Honor. I forgot to deal with that, Your Honor. He is a plumber's apprentice licensed with Union 72 of the Plumbers and Pipe Fitters Union. He was working at the time of his arrest. He tells me that when you are licensed with something like the Plumbers and Pipe Fitters Union, it is always possible for you to get a job. His stepfather also told me that he is a project manager and would be able to assist Mr. Cantrell with.
Thank you. All right, Ms. McCall. Excuse me, Ms. McClure. Had Ms. McCall.
Yes, Your Honor. So the state opposes a reduction in bond in this case, Your Honor. The state would argue that this is a reasonable bond given what he's charged with. He is charged with kidnapping. And the $20,000 bond is not excessive given the serious nature of these charges. The defendant does have one prior felony conviction. Granted, he was 17. Your Honor, this case, the facts are actually horrible. The defendant's co-defendant, they kidnapped a girl, hit her in the head, put her in the backseat of her car, and held her there against her will. So the state would oppose any reduction in bond, Your Honor, based on the very serious nature of these charges. the state does not feel that the bond that is set is excessive or unreasonable. And we would ask that Your Honor not reduce the bond.
Is this a case in which you or anyone that you know of, Ms. McClure, has been in touch with the alleged victim?
Your Honor, I believe Ms. White spoke with the victim. If she wants to, I believe she spoke with the victim in this case.
Ms. White?
Ms. White. And I believe the victim opposes bond in this case, or opposes reduction of bond in this case as well. But if Ms. White wants to comment on, she spoke with the victim, I know she did.
Let me see if I have her number.
Okay. While we're doing that, any response, Ms. Lubinsky?
Your Honor, I'd be interested to learn what the conversation was with the complaining witness. My understanding is that she told the police that she was here from Florida visiting. She doesn't actually live here. There was no relationship between the parties. The story she tells is interesting, if nothing else. I'd like to know whether there was any follow-up from anyone at all to the story, or whether they just swallowed the story she told wholesale. She talks about going to a property in Villarica. She talks about an older white male snatching her and throwing her into a shed with 5 dogs. Was there follow-up on that? Did they locate the shed and the older white male with the 5 dogs? She talks about her car being full of guns and drugs. Was her car found full of guns and drugs? She talks about Mr. Cantrell doing gun and drug deals. The police took his cell phone. Did they find any messages concerning guns and drug deals? Did any of that actually happen? Or are we just saying, yeah, she says it happened?
Okay. Okay. All right, listen, has Ms. White signed
I have
back
her telephone
on?
number.
Huh?
I do not have her telephone number.
Okay, I thought Ms. McClure was going to call.
Oh. I did email her, but that's not helping.
Okay, Miss. Yeah, I just sent her a message, Your Honor.
Okay. Okay. Well, what I'd like to do in this case, and again, I apologize for not being able to give you kind of an instant decision here, but I can't read the incident report. I can't read anything. I'm persuaded that if Judge Ashley will generally write on his bond orders some relevant information. Ms. Lubinsky, do you see that?
So, Your Honor, what I have is, of course, the pretrial report, which shows that Mr. Cantrell appears to be a fairly good risk. His risk level is 4. He does not appear to be on probation or parole, does not have more than 3 or more violations of probation, etc. Your Honor, the actual bond order, did I actually take it down? I'm not sure that I did, but it was a bond order granted at first appearance, which under the circumstances is quite remarkable. It's based clearly on the fact that this young man is a good risk. Let me try and go into Odyssey and see if I can actually get the bond order off. I was able to go.
Sorry, Ms. Levinsky. I was just saying I was able to pull it up here, the bond order.
Yes.
The only conditions that looks like Judge Ashley wrote down was no alcohol or drugs without a prescription and no weapons. That's all he wrote down, Your Honor.
Okay. All right, I will get an order out just as soon as I can. I'd just like to review the record before I make a decision. I will say that with the representation of the type of incident giving rise to this arrest, $20,000 from Judge Ashley seems kind of low.
It does.
So so he must have had some basis for taking that kind of, all right, I'll look at it and get something out as soon as possible.
I will say this, the incident report is not on Odyssey.
Okay.
Oh.
If you want a copy of the incident report, I can try and email it to you. Does the state have a copy?
No, I don't, Jenny. I've reached out to them. I'm trying to get copies of everything, so I'm still waiting, and I'll check in with them again today, but I don't have it either.
Well, is it acceptable to the state if Ms. Levinsky sends it to both of us?
Yeah, that's fine with me. I would appreciate that.
I would appreciate it too. And I just want to make clear for the record that I will consider that outside of the record. I'm not going to call Judge Ashley and ask him what he was thinking, but I think I can tell what he was thinking, and I will look at the record, the incident report, and I will get an answer out very quickly.
Thank you, Your Honor.
Thank you, Your Honor.
Okay. I'm a bit of a dinosaur with technology, and
you're not. Say that every time, but you're not. You're
but
sneaky.
I will try and get it to you today, but it may only get tomorrow when I'm actually in my office. But I will try and do it today. I actually managed to get something to Miss McClure today. So
All right, well, I'll decide that one. Are you looking for sign-on bond? Or are you looking for, what are you looking for, Ms. Levinsky?
I'm asking for a signature bond.
Okay. All right, I'll get something out. Thank y'all. Okay, everybody, that concludes that record. Everybody ready to talk about Mr. Goolsby? What did he do?
He didn't. That's my problem. So he was arrested, Your Honor, on 3 cases.
We're not on the record. Do we need to go on the record? He was arrested on 3 new charges?
On 3 new charges. And my reaction when I heard that was probably like yours. I'm going to kill that man.
Okay, keep going. Do we need to be on the record?
Perhaps.
Okay, Samantha, you ready?
Yes.
Okay, so technically these are probation revocations?
Well, actually, I filed bond motions on all of these.
When did you file your bond motion?
I filed 3 of them a while ago, and then the 2 motions to set aside the pretrial warrants were filed a couple of days ago. But the bond motions on the CP cases, I think, were filed a little further back. And I actually sent the state body cam video footage for the 3 new cases.
Okay. So I don't have a CP case on the calendar.
They're not on the calendar.
No, these two were put on the calendar because he was picked up and the court administration said we need to put these two on the calendar. So then I got the other stuff. I just haven't put those other ones on a calendar yet and thought we might just be able to talk about them, but I will put them on another calendar if that's what we need to do. But these two are the ones that court admin said you need to put these on the calendar right now.
Okay. So what I've got, so Samantha, you ready?
Yes. Yes.
This is the state of Georgia versus Thomas Blake Goolsby. And I have two numbers. One is 13 SC 121872. The second one is 17 SC 151902. These matters are on the calendar today for probation revocation. I will say that today is October the 13th, 2020. I am in courtroom 8A. I will say our courtroom is open now, and it is staffed by a member of the Sheriff's Department. We also are on the court's YouTube live stream program made available through the court's website. And we've satisfied, therefore, our obligation to make the public's business open and accessible to it. We do not, however, have Mr. Goolsby either on the Zoom or in the courtroom. And therefore, I'm going to turn this over to Ms. McClure to see if there are any questions she wants to ask Ms. Lubinsky about Mr. Goolsby's presence.
Yes, Your Honor. Ms. Lubinsky, have you had a chance to discuss these revocation hearings with Mr. Goolsby today?
I have.
And does he waive his appearance?
He waives his presence for a discussion of the cases. If there's going to be a formal hearing, he will need to be present for any formal hearing, which includes testimony.
Okay, thank you. No more questions, Your Honor.
All right, Ms. Lubinsky, tell me what you want and what we can get done in light of the announcement that Mr. Goolsby would like to be present for a quote formal hearing.
So, as I said, I was delighted when the cases got on a calendar because I think somebody needs to look at them. I have sent the state, quite a while ago, actually, I sent Miss Macaulay one of the body cam videos in one of the new cases. And more recently, I sent additional copies to Miss McClure and Miss Macaulay of all of the body cam video. And Your Honor, I guess, as I said, I was horrified when the man was arrested. How could he do this? Except that it doesn't look like he actually did it. So I got the body cam video, and if one starts with the incident 20 CP 193783, and it relates, Your Honor, to a theft of a carton of cigarettes out of a vehicle outside a store. There's actually clear video footage, not body cam, but video footage of the incident. And it's actually clear that the person who commits that offense is simply not Mr. Goolsby. It's as simple as that. You can look at it. I'd invite the court to look at it. I've invited the state to look at it. It's not him. I don't know why the case is still here when it's not him. So I guess I'd invite Ms. McClure to respond to that first.
What about before we do that, why don't we talk about 20 CP 193-824?
So that case, Your Honor, involves Mr. Culberson. And Your Honor will recollect that Mr. Culberson is the complaining witness in the 20 SC case.
Is he the one that owns like a
Pawn
pawn
shop. So in the 20 SC case, I asked repeatedly for the video footage from that incident because there was no evidence that Mr. Goolsbee committed that offence, save and except for Mr. Culberson's claim that he could identify Mr. Goolsbee from the video footage. But we never received the video footage, and the last I heard from Miss Macaulay is that it didn't exist anymore. I don't understand that because it was supposedly actually given to the police. But I do know that when the police and Mr. Culberson looked at the video footage together the first time, there was no way anybody could identify anyone at all. So Mr. Culberson is now the victim again in 20 CP 193-824. And there's video footage. And there's video footage of a person doing stuff. I have no idea who that person is. I cannot say that it's not Mr. Goolsbee with 100% certainty, like I can in the other case. But I cannot say it is him. In fact, it is clear that the person cannot be identified. And in fact, Mr. Culberson is on video saying to the officers, yes, well, we cannot identify the person. So there's no reason to assume it's Mr. Goolsbee, other than, as I said, the assumption that we want to blame every unsolved car break-in in the area on him. And the same sort of applies to 799, the case ending in 799. There's talk of video footage there. I do not see the video footage, but nobody there says they can identify anyone. If there is an identification and clear video footage identifying Mr. Goolsbee, I would love to see it. But otherwise, it seems to be that there's absolutely no evidence connecting him with these offences.
Where's he been living? Do you know?
Your Honor, I had some stuff on that.
You know, at some point he was at a church, and then the veterans were trying to find him something.
Veterans tried to find him something. He was staying somewhere. I think it was in a house somewhere because I think his SSI was on. Actually, he gets income from two sources. He gets income from the vets, and he also gets income from, he worked for GM, General Motors, for something like 18 years. And he does get income, and he had accommodation.
Okay. Was he reporting?
Yes, he was reporting regularly to Miss Redden of pretrial services.
Okay. Okay. Ms. McClure?
Yes, Your Honor. So I'll just respond to what Ms. Levinsky said in the best way that I can. Mr. Goolsby does have a lot of open cases. I need to familiarize myself with all of them. I have noted what Ms. Levinsky said about the cases and the evidence, and I will be sure to go in and review all of that and try to get with you later this week about his cases. I also reach out to the police agencies again and see if there's any outstanding evidence or video that we haven't received. At this point, Your Honor, the state just needs to review everything again and get with Ms. Levinsky about the case. He does have probation. I know he's on probation as well. So we would like to try to resolve everything at one time if possible in the future. So
We all want to solve Mr. Goolsby.
We would love to. And I agree with you. He's got a number of open cases.
I know that every day in jail is not a good day. And putting this off does nothing. Certainly not for Mr. Goolsby. But, and I'm not responding to the volume. It's not that volume necessarily counts here, because candidly, there may be something to what Ms. Levinsky is saying is, I've got a likely suspect here. Anybody got a crime? I get that. And you know, I came to Mr. Goolsby's ultimate decision back in, I think, June or whenever it was. I may be confusing Mr. Evans, but came to the ultimate conclusion. He's always gotten the benefit of the doubt from me because of his veteran status. I mean, you don't fight for our country and then have a pretty distinguished career and not have some reason for all of a sudden breaking bad. I mean, clearly he has a problem. Let's do this. You started out by saying he doesn't waive his presence for any formal hearing. Kathy, can we get him on our next jail Zoom? And by that time, Ms. McClure and Ms. Levinsky, if you could talk about this video.
I think,
and I'm not trying to put
all of these videos.
Sure.
The state would just like enough time to make sure that I can review everything.
No, I understand. And I'm not trying to put it off. I mean, we've all wrestled with Mr. Goolsby. If he wants, but I think maybe let's have him on camera at least. Can we do that?
It's at the end of the month, so so we're putting all the cases on there for a hearing. That
sounds good. That sounds good. But
okay.
But Lindsay, if you can, look at his jail booking photo.
Okay.
And look at.
You sent me the video. You sent me some videos.
Yeah.
Okay. I'll take a look at everything.
You'll see what I mean very, very quickly.
Okay.
And if I can pinpoint you to the exact video.
Okay.
Okay, I think that ends us for today. Again, I hope everybody is doing well. Those things that I promised you that I would get out, I'll get out. And what do we have tomorrow? Kathy, do we have something tomorrow?
We have 9 o'clock tomorrow.
Ooh, 9 o'clock Zoom?
Yep.
The Zoom or in person?
It's Zoom.
Okay, I'll be present. Is anybody coming to the courtroom?
We will be in the courtroom tomorrow. Yes. I don't know that anybody's coming for sure.
Okay. Because Kathy told me today that the reason that we didn't have a deputy was because they told us to get out of the courtroom because of some heating issue, but.
Nobody's there
everything's
working on it, right?
Okay, no. So I'll see you guys tomorrow at 9.
Thank you.
All right.
Not-
All right.
And Your Honor, I just want to thank you for your patience with me. I'm adjusting and doing 2 jobs, so I just want to thank you for all your patience.
Listen, we are all adjusting. Okay, thank you all very much, and I'll see you tomorrow.